r/legal advice. Throw name says. Car stolen while at dealership for service. We dropped off our car for service with a full tank of gas and our app kept telling us weird things were happening in the middle of the night. We figured it was just wonky from the service performed. When we went to pick it up, the odometer read plus 345 miles from when we dropped it off, and the tank was empty. We have filed a police report. Is there any other action we should be taking? I appreciate any help. Stuff S says. Speak with the GM of the store and possibly escalate to corporate of the brand. At this point it's damn near impossible to prove damages, but the store will try to appease you. You might get about 50 cents per mile driven though based on the IS calcs. Ziziva100 says. Escalate to corporate for that car manufacturer. The actual car makers really don't like when dealerships do shit like this, and the dealerships can lose allotments of cars for bad behavior, which means they don't have cars to sell. See what they are willing to offer as compensation after you contact corporate. A simple tank of gas is not nearly enough. Mattlines98 says. What do you mean your car was stolen? How do you know the mechanic working on it wasn't driving it? Generic user 69143 says. Your car was there and you picked it up. At no point was it stolen. The police are not interested in a missing tank of gas, and it is very unclear that there would be anything even minorly criminal here. In theory, you could sue, but your damages are limited to a tank of gas and a couple of miles on the odometer. In reality, this is a customer service issue that you take up with the manager. r/legal advice. The Hammer 8989 says. Multiple animals killed by dog. So a dog from a nearby neighborhood got loose and killed a few people's pets. There were 2 cats we know that got killed. Another attacked. We already figured out whose animal it was, and they admitted to it. The animal is on camera. Not attacking but in the neighbor's yard next door on their camera. One of the animals in question was actually killed on a porch. The porch was a closed-in porch with a door on it. 100% closed-in point there. Dog actually broke through it to attack and kill the cat on its porch. My question is, the sheriff out here said that since it happened outside nothing could be done by him. I believe that's incorrect. I was told a closed-in porch with a door is actually considered part of house itself. Similar with them needing search warrants to enter a locked porch connected to the house. Any information on this would mean so much to the families that lost their animal. Maybe if I had actually information on if this was true, the cop would realize he made a mistake and do the right thing. State this happened in Illinois. And the dog was a pit bull mixed breed. Thank you for any answers or advice. Is there any kind of ticket they can give the owner? This animal has been loose several times. First time I'm aware that it killed anything though. Thank you. Tom Mossel says. Sheriff is full of shit. People can't have their dogs loose. The actual charge is known as dog at large, I shit you not. Silver Cat says. You should report to animal control instead of the sheriff. They are more equipped to deal with animals. r/legal advice. Throwaway AI says. Just got hired. My employer made a comment about not paying me for my first few shifts. What are my options here? Got hired at a place very close to me with pay that I'm happy with. I was hired on the spot after my interview, and while showing me around a little and telling me about what he'll be doing, the owner made a comment about how I won't clock in for my first few shifts since he'll just be watching and won't actually be doing anything myself. Is this legal? I've never been told anything like this before, and all of my training at prior jobs, no matter how little I did, was paid and on the clock. I do want to work here. Is there a tactful way to insist that I get paid for those shifts? USAC 1748 says. To your legal question, if you are in the United States, under the Fair Labor Standards Act and likely a state analogous law, you have to be paid. The language in 29 USC sections 203 G and 206 have been interpreted by courts as requiring employees to be paid for all time suffered or permitted to work. The more nuanced answer is that your future employer has, before you have even started, acknowledged that they don't mind violating workers' rights. There is no tactful way to insist that you get paid for the shifts. You must weigh the chance of a difficult employment or having your offer recessed and reporting the company versus your need or desire for employment by this employer. There are civil and possible criminal penalties for the employer if the relevant agency decides to examine and move forward with your report. There is no monetary reward for you. The only damages would be the unpaid amount if you chose to attend the training. Average_pornster says. Not legal, they have to pay you for your training. File a wage claim with your state if they pull this BS. r/legal advice. Behind cherry_ says. CA, ex-boyfriend who won't stop harassing me for 6 years is representing himself in a court case as his own attorney, but he continues to publicly disparage, defame and harass me, as well as talk about the court case and its details. Is this illegal? My ex-boyfriend is a petitioner in a case against me where I'm the defendant. I have an attorney representing me in this case A, and my ex is representing himself as his own attorney, pro se. My ex knows I have an attorney and has been told by my attorney and judge to only contact my attorney, not me. Despite this, my ex continues to contact me, but more importantly, my ex is publicly posting disparaging, defaming, and case information online, as well as talking to people about it openly. I have filed a restraining order against my ex, case B, because my ex will not stop harassing, stalking, disparaging, and defaming me, despite a judge telling my ex to only talk to my attorney. He continues to post and talk publicly about the cases and me. I cannot afford an attorney for this case. I'm broke because of case A. My question, isn't it illegal for my ex to be posting publicly and talking about me and the cases because he is his own attorney in case A? He is publicly posting and talking about the case A, its details, me, and disparaging and defaming me. Please help. It's been 6 years of dealing with this, and it's causing me severe mental and emotional anguish, and has caused me job loss, because people can see his public posts. The restraining order case is coming up, and I hope my ex is forced to. Judd 43 says. It is generally not illegal to make public posts talking about ongoing litigation. It shows poor judgment, because it is easy to say things that hurt your case, but it's generally not illegal absent a gag order or something along those lines. Regarding defamation, if you feel he has defamed you, that is, told lies about you that caused you actual damages, your remedy is to talk to an attorney that specializes in those claims. You should know that defamation claims are very difficult to prove. Magnolia 888 says. A lawsuit generally isn't confidential, it's public information and he can talk about it as much as he wants to whoever he wants, and blab all over FB. It's usually a bad idea, but not illegal. There are exceptions, of course, if there is a gag order or a protective order governing the use of documents in the case, but it doesn't sound like you have that in your case. Defamation is another situation altogether. If you believe he has been spreading false and defamatory information about you that injures your reputation, you'd have to sue him for that, so you'd probably need a lawyer. It can be very hard to prove, and it can't be based on mere opinions, but demonstrably false facts, and you'd have to show that you've been damaged by his conduct. r/legal advice. One Infinita Loop says. Management deducted $2,000 plus from the security deposit to repaint the apartment. We vacated our apartment in New Jersey on February 28th. On April 12th, we received a check, dated April 11th, for $338 as a refund from our security deposit, which was initially $2,400. The largest deduction on the refund was $1,500 for repainting the entire apartment, remaining amount for cleaning the apartment and shampooing the carpet. However, when we moved into the apartment a year ago, there were already stains on the walls, and the paint was chipping off in many places. We documented these defects through photographs and also informed the management using the move-in sheet. Now that we have moved out, the management is charging us the full amount for repainting. We tried reaching out to them via email last week, but we haven't received a response. We are considering taking this issue to small claims court, but we don't have legal representation and are unsure of the procedures involved. We want to avoid incurring additional legal expenses. We would appreciate any suggestions or advice on how to handle this matter effectively. Cat of the Decade says, keep trying to contact the landlord. Ask when the apartment was last repainted. Painting is a normal wear and tear item that needs redone from time to time, so unless you caused excessive damage to the paint, your landlord doesn't get to enrich themselves at your expense by forcing you to repaint the apartment for them. You ultimately may need to take this to small claims. Alternatively, you could try filing a complaint with your state's attorney general. They likely won't pursue criminal charges or anything, but sometimes a letter from them can be enough to encourage a landlord to stop trying to scam their renters. That's all for this video. Thank you for watching. Please subscribe.